Hello, everyone. Please welcome Chris Ball.
Thank you so much, Diana. I appreciate the introduction. Welcome to our presentation this afternoon. This is one of my favorite topics. We're going to address the top financial mistakes to avoid when you're dealing with a dependent with special needs. So we'll be sharing a lot of information today, a lot of topics that are typical scenarios that we see that we end up talking to clients about and addressing these issues as we do our planning. So looking forward to sharing this information. And like I said, I know it's a lot of information, but it's important. And you'll see as we go through this that we address these issues as we go through our planning, and we make sure that we have protections in place to address these issues and make sure that our plan works for you and your family. That's our main objective always, is we want to build a rock solid plan that protects you, protects your loved ones. And we want to make sure that we accomplish all the goals, the dreams, the objectives you have for your loved one needs. So real briefly, just want to introduce myself a little further. I'm one of the co-founders here at Stalt Financial. There's 3 of us. When you work with us, you'll also get to meet Dan Zeck and Kat Toon. They're my partners in Stalt Financial, and we're really excited to do this type of work. I'm the director of our special needs planning group, and this is something very passionate for me, very near and dear to my heart, very important to all of us here at the firm. This was something that all of us held very special. My background in getting into this type of planning was through experience with family members. I have a very large family. I have several of my family members that have special needs. I have several loved ones that are on the autism spectrum. I have a loved one with Down syndrome. And then I also have a cousin with spina bifida. In addition to that, I have many close friends that have children with various intellectual and physical disabilities. And I've seen the issues that they've dealt with and trying to navigate the system that we have and trying to get benefits and ultimately services that help them, help their loved one, enhance quality of life for the whole family. So having seen that and knowing that this was a focused line of work in our profession, I was very drawn to it. So I went and got a certification from the American College of Financial Services, which is called a Chartered Special Needs Consultant, which gave me more insight and helped equip me to better serve families that have special needs, because there's a lot of areas of planning that we need to address, as you'll see here as we go through our presentation. And then finally, I'm excited to announce I've been working on a book, Making Sense of Special Needs Finance, a Caregiver's Roadmap to Financial Stability. So that should be out shortly. Again, another tool that I hope can help you best serve your family, get the information you need to build a rock solid plan that helps, again, serves the needs of you, your family. So we want to think not only about financial issues, but also an entire life care plan. We'll talk about that as we go on here. So what about some of the issues that we face? What are some of these issues I'm talking about? Well, let's switch gears here. We'll get into the main part of our presentation. And like I mentioned, it's really good to highlight all these various issues that come up. There's a lot of misconceptions with planning in this space. A lot of well-intended people don't always have accurate information, or what happens a lot of times is things change, right? We're dealing with a legal system. We're dealing with laws that change. We're dealing with benefit changes, tax changes, all these things that come up. And it's important that we stay on top of it, that we navigate this, that we get it right. So one of the things I want to first share is the legal part of our program here. I'm going to share a disclosure. So as it mentions here, the information provided is not written or intended for tax or legal advice. MassMutual, its subsidiaries, employees, and representatives are not authorized to give tax or legal advice. Individuals are encouraged to seek advice from their own tax or legal counsel. Individuals involved in the estate planning process should work with an estate planning team, including their own personal, legal, or tax counsel. So, important to note here, obviously that's a legal disclaimer, but essentially what it comes down to is we really want to stay in our lane, focus on the financial aspects, but we also make sure that we work with a very qualified team of professionals to serve your family. So we want to always make sure that you have the right people on board that help build a rock solid life care plan that help you serve your family in the best way possible. So let's get into our first point here. We want to discuss one of the first things we would want to avoid. Years ago, it was very typical, because most of our loved ones that have special needs that are on government disability or another program through the government, well, they have to remain qualified for those benefits. And you're probably familiar with some of them. So let's take a program like Medicaid. With Medicaid, you can only have $2,000 or less to your name, $3,000 if you're a married couple. So the thinking in the past always was, well, I don't want to disqualify my loved one from Medicaid. I don't want to impact their government benefits. Maybe it's SSI, which is a supplemental security income. Maybe it's Social Security Disability, one of those programs. So instead of leaving money directly to them, we'll just disinherit them. And then that way we don't have to worry about having assets in their name. So the thinking there was, as our first point brings out, people rely on those benefits. It covers food, shelter, medical care. But if you're familiar with those programs at all, they really only cover the bare bones, the absolute necessities. And quite frankly, they don't always do that. For example, a person getting SSI this year gets $914 a month. That's the maximum benefit. Medicaid covers a lot of services for our loved ones with special needs. We'll continue to talk about that as we go on here. But the bottom line is, there are a lot of ways to leave money to a loved one with special needs without disqualifying them from government benefits. So it would be very, very rare now, probably a very special, unique case where you would ever consider disinheriting someone with special needs. Likely, you would leave them benefits in the form of a trust, which we'll talk about. We're going to talk about ABLE accounts. That's another tool that can help our loved ones, particularly when they're in adulthood, 18 years and older, that will help protect their government benefits, and we can provide additional funding to help with their quality of life, help them get the services they need, but also get enjoyment and enjoy many of the things that may not be available if our funds are limited. Second point tied to that, I touched on Medicaid. So we're aware of this as our loved one is approaching adulthood, that we would want to be very mindful of assets that they have in their name. What you'll see a lot of times, perhaps you've seen this even maybe not only with a loved one with special needs. I went through this with my uncle, who was elderly, who didn't have a lot of assets and was in critical need of long-term care. He had to qualify for Medicaid. So we had to spend down his assets to make sure he remained under that threshold of $2,000 and was able to stay in his nursing home, was able to get the care he needed full time. Perhaps you have accounts set up for a young one that's not 18, and you've set up perhaps a 529 account for college education. Maybe you set up an account, it mentions it here, Uniform Transfer to Minors Act account, commonly referred to as a UTMA account. Maybe that your child had savings bonds. Well, we'd want to make sure that those assets were retitled when they get to be an adult to preserve those important government benefits. Medicaid, again, is really the critical benefit that we want to keep in mind. Medicaid opens so many doors with our loved one with special needs. Some of the programs are limited depending on the state we live in and things like that. But overall, having that critical health benefit is vital to their care. And you can see some of the other issues that could potentially come up. If we have a loved one with special needs, they likely in adulthood would need assistance managing money, dealing with various issues around their personal finance. We'd want to be very cautious, make sure that any assets were titled properly, not only to preserve those government benefits, but also reduce risk if there were any predators out there, identity theft, any type of lawsuits or bankruptcy situations. So sadly, those do happen. So we have to avoid that at all costs. And the other one I mentioned is their spendthrift situations. That is when someone takes advantage of them and spends their money. One quick note on this slide. One of the things I get asked about frequently is with parents that have started an education account for a child, as they go through school, start thinking about a transition plan around maybe age 14, 15, sometimes the parents realize that it's not likely that their loved one would go to college or higher education, so they wonder what to do with those funds. Well, there are options available. If you have an account like a 529 or the UTMA account it mentions here, you can actually move those into a tool called the ABLE account. So we'll talk about the ABLE account here in a little bit, but that's another important tool when your loved one gets into adulthood that we can continue to have funds available specifically to enhance their quality of life. This slide here is really important, and I think this really deserves a lot of consideration and conversation. I've talked to many well-intended families, usually a mom and dad. Perhaps they have several children in the family. They are apprehensive about leaving money in a trust or setting it up in that fashion, just because of the unknown, some of the legal challenges around it, making sure it's done right. So the thought is that they would leave money directly to another person, and they would take care of their loved one with special needs. And as I've told many of the families with this idea, that's very well intended. And it's certainly not my place ever to question the intentions around someone's desire to do that. Most of us deeply care about our loved ones. It's a labor of love with our family member among many people, mom and dad, grandma and grandpa, brothers and sisters. We're very well vested in the care of our loved ones. However, even if everything is perfectly well intended, there's a tremendous amount of risk in this type of planning. And it opens up so many dangers that could potentially derail the care of your loved one. There's good questions here, right, to think about. What if the assumed caregiver dies, gets divorced, gets sued, or goes bankrupt? Well, that money could be gone forever. Sadly, this happens way too often. What happens if perhaps you have 3 children and you leave money to your oldest child to take care of your youngest who has special needs? Let's use that scenario. Well, if they die, if they don't have a proper estate plan done, we could end up losing that money to a probate court. Not sure exactly what could happen to those monies, but it's likely they won't go to the care of our loved one. If they get divorced, think about the state you live in. What are the divorce laws? With a divorce settlement, they could potentially give half of that money away to their ex-spouse. Well, that would be a loss. And those funds could be gone forever. If they get sued, what if they are in a car accident and injure someone severely or hit someone that's a very high earning individual and they have a tremendous amount of liability on their hands? Again, you see where I'm going with this. So very dangerous with this type of plan. Again, knowing that it's with the best of intentions often, and looking at the other side of it, the last point there, sadly, there's often just a lack of accounting that takes place. Funds could be mismanaged. Some of our family members, although they're wonderful people, aren't always necessarily good with money. Would they be able to handle that amount of money with this amount of responsibility? Those are all really important questions to consider. That's why typically funds like this would be left in a trust. We'll talk about that a little bit later on, why that trust is such an important vehicle when we think about protection and making sure that the money gets to exactly where we want it to go, which is the care of our loved one, and we've protected all of their important government benefits in the process. Here's another point that's really important to discuss. Again, a very emotional point for the family. This requires a lot of important conversation, a lot of thinking in the family and honesty. Assuming who will become the future caregiver. It's interesting, this comes up with families, even with children at a very young age. One of the local nonprofits that we work with, I had a really good conversation about this very topic a couple weeks ago. And typical scenario, let's say you have, let's again use 3 children. Maybe you have a 13-year-old, a 10-year-old, and a 7-year-old. Perhaps your youngest child, your 7-year-old, perhaps they have special needs. It's not uncommon to start having your then 13-year-old and 10-year-old in our scenario think about being a caregiver already at a very young age, because they hear conversations, they know what's going on with their sibling, and they know that this could be potentially a situation that they have to deal with. So there's a lot of counseling that goes on often now, even with a lot of our facilities that provide support for families, talking about this very topic, because that gets on the mind of the family very early. But notice what it brings out here. It talks about the moral obligation. It could be thrusted on an individual, perhaps your oldest child. They're used to taking care of the family. Well, now they have this big obligation to take care of their sibling. And unfortunately, human nature and just all of us trying to take care of our own families, our own health, well-being, sadly, sometimes that causes resentment. And it's important that this is discussed. It's important that this is a frank topic of conversation in the family. And there's other considerations here. What happens if your child is earmarked to become a caregiver? Well, then they get married. What if they start a family? Would they be able to then give their sibling with special needs, would they be able to give them the attention that they really deserve, the level of care that they need? If the person is married, would the spouse be understanding? Would they be supportive? Sadly, that happens too, where perhaps a potential marriage mate sounds like they're on board. Well, then when reality sets in, they may not be on board. And that can cause a lot of discord in the family, cause a lot of stress on the marriage. There are alternatives to think about. And more, there's programs available that provide supported living for our loved one with special needs. It mentions here on the slide, we may think about guardianship. If they're simply unable to take care of themselves, we may have to appoint a legal guardianship over them and help them, assist them, take care of them. That can be done, if not done by a family member, there are professionals that do that and still give them a quality of life. Perhaps allow for some independent living, allow for a situation that benefits the whole family. So really important thing to think about, and through good communication, again, not always easy. Having been through this conversation with loved ones, family members, and clients, I know it's not always easy, but we bring that up and we help facilitate that because it's really an important part of the planning process to make sure that the entire family has a quality of life. And we want everybody to be able to enjoy their relationship as family members. Next point to bring out, not having the right kind of special needs trust. So it's important that as you get set up with your planning, as you look at all your planning needs for the estate, if you decide that a special needs trust is indeed the right vehicle for your loved one, we want to make sure that we have the right one in place. So there's different ones here. You'll see them mentioned. The most common one that we see that is typical of most families would be a third-party special needs trust. Third party meaning that it's not set up by our loved one. It's set up by another person set up for their care. Most likely would be you as a parent, could be grandparents. It could be established by someone other than you, but it's likely that it would be you or a third party. A first party special needs trust is usually where perhaps our loved one gets a settlement. Early in life, they're given some funds, and because the funds are in their name, but we know that they're going to need a lifetime of care, that would be a first party trust. It's established with their money, set up for their care to protect their government benefits. There's pooled trusts where you can pool your money with other families. That's a situation that is economical feasible for a lot of families where they may not have a ton of assets to pass on to a trust, but they want to be able to provide something. There's pooled trusts. The Special Needs Trust Fairness Act is relatively new. That's part of the laws that came about within the last decade, allowed more protection for trusts, allow more vehicles for these trusts to be established, provide that critical protection for our loved one. When that trust is set up, though, not all trusts are created equal. And we want to make sure that we have a very competent expert in special needs estate planning take care of it. The three questions there that it asks: how does it protect a dependent's government benefit eligibility? What exactly can it provide? That's something that the person establishing the trust would dictate. So you have options on what it can provide. Again, usually providing quality of life enhancement. I've even seen special needs trusts have language where the loved one is a big fan of Disney, and they're earmarked every year to take a trip to Disney with their caregiver. That can be part of a trust. There's a lot of options there. Third part, are there any restrictions that we need to be aware of? So we want to make sure that we have the right person designing the trust, doing the trust, and they'll be the one that is going to ultimately help us execute it down the line. So things that we need to be aware of. So first, we want to make sure we have the right vehicle. And then second, we want to make sure that it's funded properly. This is an important point right here at the top. A special needs trust does not have to be funded at the time it's created, but it's useless if it's never funded. Sadly, we catch that in our planning at times. So mom and dad or grandma and grandpa have done the right thing. They set up a trust. So usually what'll happen is you go and get a trust set up for the family. While you're doing that, there's language that can be put in to add a special needs trust or perhaps add it later on. But as all of this is done, there's nothing that is there to fund the trust itself. Talking about beneficiaries, talking about funds that are earmarked to go to the trust, that's not set up. Unfortunately, if something happens, then there's no money that gets to the trust. So it's important that proper forms are set up, beneficiary designations are selected. That has to be done in order to fund the trust. So beneficiaries, we'll talk about that. Very, very critical part of our planning. That's a critical part of our ongoing planning with every one of our clients is beneficiary changes, making sure that it's up to date. I was just reading a long article today about Kobe Bryant with the tragedy that his family went through. When Kobe passed away, he had a trust set up. He had obviously a very large estate, but with the tragedy coming so soon after the birth of his last child was actually not included in the estate planning. So they had to go to court. That was a very widely known case. There was media talking about it. Usually a trust, we set that up to keep privacy and keep our financial business as personally quiet as possible, so it's not public record. But obviously with a high profile situation like that, that was well known. So making sure that things are up to date, that's really important. If you have a life-changing event in the family, make sure that those things are up to date. Oftentimes our estate planning attorneys are ready for that. Just some brief language that needs to be changed. But if there are any changes in your life, it's important that you keep that in mind. And like it says, best to work with a financial professional and an attorney that specializes in this type of planning. We want to make sure that we get it right for you and your family. Next point, improperly drafted special needs trust. This is another really important point. I've talked to many families who I'll give a presentation. We'll talk about these type of trusts. Hey, you know what? Great. I got a buddy who's an attorney. That's wonderful, but please make sure that he's an estate planning attorney that is very well versed in special needs trusts. Really important. I know cost is important to all of us, making sure that things are affordable. You have a lot on your plate financially, trying to take care of you, your loved ones, your family. Certainly, that's a well-made point with a lot of people we work with. However, if the trust is not done properly, it can have all kinds of negative ramifications. Number one, the money may not get to your loved one. Number two, it could disqualify them from their benefits. Number three, important point here, state-specific verbiage must be included. Why? Most people think of Medicaid, you think of the federal government, right? Medicaid, Medicare, Social Security. It's important to point out that Medicaid is a state and federal run program. Each state has very specific laws on Medicaid, how it's administered in the state, what benefits are available. Many of the state laws are quite similar. There's a lot of things that track almost verbatim, but there's things that are not. And it's really important that you have an attorney in your state and the state where your loved one is going to be that drafts this language. If your friend, he may be an incredibly talented litigator, maybe the best patent law attorney out there, but if they're not an estate planning attorney with special needs experience, again, we're putting risk into the drafting of the trust because we want to make sure that it's done right. It's a very specific area of law, and we want to make sure that your trust is set up properly and that your loved one is protected. The number one question every one of our clients think about all the time is what happens if I'm not around to take care of my loved one. The trust is the vehicle, usually the most important vehicle, where those wishes, where those dreams and hopes for your loved one are expressed. It not only holds the funds, but all the other legal directives that go into that. That's going to be what is your life care plan for your loved one. So we want to make sure that we have the very best experts available to do that. You see some organizations noted here on the slide. Those are three groups that I work with specifically. Those are all excellent attorneys, have worked with several of them already around the country, recommended to clients that have needed an attorney in another state, and people that are part of these alliances, the special needs planner, elder law attorneys, they're experts in their field. If you ever need assistance with that, I'm always happy to help you connect with someone who can assist you. Next point to talk about, not considering an ABLE account. ABLE account is something that's relatively new. You can see that that was put into effect from the ABLE Act back in 2014 by President Obama and his administration. What that does is it allows a loved one with special needs, an individual with disabilities, to have an ABLE account set up. How does it work? It's very similar to a 529 plan. We're here in Detroit, automotive, so I always talk about it's built on the same chassis as a 529 if you think about a car assembly line. Very similar to a 529 plan, the way it works. What it says right here in our second point, an ABLE account allows the use of funds for any disability-related expense. This is another tool that we can hold funds for our loved one to spend on them and enhance their quality of life. There's a lot of questions. I probably get more questions about ABLE accounts than almost any other planning tool, just because it's new. And unfortunately, like a lot of benefits that we have out there, there's just not a lot of information out there that's readily available to families on how they work, how to set them up. So I end up having a lot of conversations around the ABLE account. Just a few points to think about. ABLE account is particularly important when our loved one is in adulthood and we're preserving their government benefits. We're thinking about an adult who is, let's use an example, they're on SSI and they have Medicaid. Again, we're very concerned about making sure that their assets are under $2,000. We want them to qualify for their benefits. That's particularly the time where this tool is handy. For younger children that are not in that situation yet, probably not something we have to worry about funding immediately. As your child gets older, we start to get an idea of a transition plan into adulthood and what their needs will be. This certainly could be a very valuable tool. As it mentions here, many of the states have adopted ABLE legislation. Since we're in Michigan, I'm mostly familiar with the Michigan plan. This is similar to with the Medicaid laws. Every state's a little different. One thing I like to point out here in Michigan that's not true in every state is in Michigan, you can actually get a tax break on your state taxes here. There's no tax write-off per se at a federal level, but the state of Michigan does give you a tax benefit on these accounts. And then they work very much in a similar vein like a Roth IRA, if you're familiar with those. The money goes in after taxes, the money grows tax-free, and the money can be taken out tax-free. So that's the benefit that we have with those accounts. We have some tax advantages, and more importantly, we can use that for our loved one. There is a cap on these. They can go up to $100,000. So they're not meant to accumulate a ton of assets where we would have millions of dollars in an ABLE account. There's a cap on them of $100,000. If you go over that amount, that could start to impact your monthly SSI benefit. So again, something we want to be mindful of. These are meant to be spent on our loved one and enjoyed. And there's only one ABLE account per person. Anybody can contribute to them as it brings out family, friends, your loved one. Maybe they work a little bit and they have a part-time job, they have their benefits. They can put some of their savings into the ABLE account. Trust can put money into an ABLE account. Like the 529, there's a limit on that though too for your annual contribution. This year it's $17,000. That runs right with the gift tax limit for 2023, $17,000. of a gift tax benefit, and that tracks on that amount the way it's set up right now. So really important tool to consider. Like I mentioned, always happy to help answer questions around these. The website mentioned there is excellent, www.ablenrc.org. That's a great website. A lot of information for you there. So think about that, particularly if you have a situation where your loved one is approaching adulthood or they're in adulthood. Oops, sorry. Next point, failure to communicate future plans. Like anything in life, communication is really important. We like to particularly bring this out with your circle of care. Share your future plans with your family and friends. The reason we bring this up is there's a lot of well-meaning people, and it's wonderful to have those in our life, right? That want to be of assistance. They dearly, dearly love their loved one, your loved one with special needs, perhaps their friend, their family member, could be brother, sister, cousin, whatever the relationship is. Very important that they're aware of their situation with their benefits. Like it brings out, you never know who may want to leave assets to a dependent with special needs. You always hear about in the movies, right? The long lost aunt or uncle that leaves you a windfall. Mine hasn't come forward yet, so I'm still waiting, but right? You hear about that though, right? People well-intended may want to leave a gift behind, leave a legacy to your loved one. That's wonderful. Well, unfortunately, the laws are structured the way they are. If a well-meaning individual left money directly to our loved one with special needs, we could impact their benefits. So it could really undo all this wonderful planning that you've done. And it's just important to communicate that. So anyone that's in your circle of care that has a vested interest in your loved one, again, not always an easy conversation to have, but if you have a circle of trust there, let those folks know that this is how these benefits work. Things are structured in a certain way. The estate plan is structured in a certain way to protect your loved one. And really, we want to build a rock solid care plan, not only for now, but also for the future. So that care plan is predicated on making sure that these type of things are set up properly. If anyone does want to help out, if we have, let's say, a trust in place, they could leave the legacy to the trust, and that money will go exactly where they would want it to go for the care of our loved one. Failure to review and update beneficiaries. This is another critical area, very important part of our planning. We could have a whole presentation on this, and we could talk about horror stories, unfortunately, with this issue of failing to review and update beneficiaries. I'll share just a couple of quick stories from my career, but I've seen this firsthand where this wasn't done. Well-intended family members thought they had everything set up properly. Beneficiary information wasn't up to date, and it really caused a lot of heartache for the family and cost people a lot of money, frankly. So any type of account that you have where you have beneficiaries, we need to make sure we review those regularly. I talked previously, and we'll get into more about wills and trusts, keeping them current. But even when you have a change in your family, a new family member updates, it's a good time to make sure all this is done. And think about all the accounts where you have beneficiaries. Life insurance accounts, annuities, IRAs. I remember starting my career out when I was in my early 20s. You get your first 401k plan at work and you're signing these forms. Beneficiary, well, I don't need to worry about that. I'm not married. Oh, you know what? I'll leave it to mom and dad. Okay. Well, then what if I forget to look at that for years? Mom and dad have sadly now passed away many years later. Where does the beneficiary money go? Well, it's likely then going to be decided by someone other than me, sadly. That's what happens. Couple stories from my background, I mentioned, had a situation here where a couple was married, they had 2 children, and they decided to get a divorce, but they had taken out life insurance policies on each other. So when the divorce happened, they wanted to maintain that life insurance, thinking that if sadly something happened, the money would go to the other ex-spouse, and that would take care of their 2 children. So life goes on, both of them get remarried. They now have new spouses and have added to their family. Sadly, in the situation that I worked on, the ex-husband died, and he had left his beneficiary on his life insurance to his ex-wife, thinking that it would go to the care of their 2 children. Unfortunately, when they did their divorce decree, she had told me that, hey, we did a quickie divorce. It was very simple, and we just did it through the county. I did most of it on my own. Sadly, there would have, in the state of Michigan, there would have needed to be legal language in there that in that divorce decree that intention of that life insurance was for the ex-spouses. Sadly, that wasn't in there. So when she filed the paperwork with the life insurance company to get the money, they told her that she was not eligible to receive the funds according to state law in Michigan. The money would have to go to their oldest daughter, the next of kin, the next in line. So the money went to the daughter. Unfortunately, her daughter was only 12 years old, meaning she's a minor. The money could not be used until she was 18 years of age, and then it would become available to her alone. So sadly, in this situation, the money, the death benefit was paid, but it only went to 1 child. The money could only be accessed when she became an adult. It had to actually stay in a UTMA account, one of those minor accounts that we talked about. And unfortunately, the mother was not able to use that money that would have been very critical for the care of those kids between ages of 12 and 18. Then you also have another scenario where the money is left to 1 child and not to the other. There was no legal obligation for the 12-year-old to leave money for her brother later on. So very sad situation, one that was not, everybody, again, well-intended, thought they were doing the right things. This issue with the beneficiaries and the language in the divorce ended up costing that family very dearly. So very important that we review this. The questions here, have you forgotten who you named as a beneficiary? We see that all the time. Another example, I worked with a gentleman who was a new client. He had a really good life insurance policy, one that was, he paid a lot of money for every month, and it was a very good policy he had had for many years. When we reviewed his beneficiary information on the policy, he had been married and had children with his wife. The beneficiary on his policy was his ex-girlfriend in college, because that was his relationship at the time when he got the insurance. So if tragedy would have struck, again, you can see how his family would have been impacted. Like I mentioned, lots of stories in that area. They're very sobering when you hear about the real world impact on it. So we want to make sure that we get it right. And notice the last point there. If we have a trust set up, a special needs trust, we talked about one of the issues is a trust not being funded. Oftentimes they're funded through a beneficiary designation. Leave life insurance to the trust or a portion of life insurance. Leave a portion of money from an account to the trust. We have to make sure that the beneficiaries are correct. Failure to create or keep will and trust current. We talked about that a little bit earlier. I mentioned the Kobe Bryant situation, just reading on that estate planning case and how his new child could have been excluded from the estate if the judge would have not ruled in her favor. So notice the point here. dying intestate means dying without a will or a trust, and everyone has a will even if you didn't create it. In other words, the state government will have a plan for your estate. That's what happens. You may have heard the term probate. That's where the judge gets to look at all the assets that you have, things that are not earmarked specifically. If, let's say, a beneficiary designation isn't there, or something isn't titled properly, or he gets information like we've talked about some of the mistakes that are made. What if something is beneficiaries left to an old relationship or someone that's deceased? Well, the judge is going to be taking all that information and they'll be the ones making the decision. If we have a loved one with special needs, we can allow that to happen because it the potential could be there where the judge does not decide in the favor of our loved one with special needs. If we don't have a vehicle of protection for that money for them, we know what could happen potentially. So we want to make sure that distributions are done in the right way. If the will isn't done properly, let's say the house isn't, I leave my house in my will, I've got everything else titled properly, but I'm going to leave in my will, I leave the house to my 3 children or the trust. Again, I've created a problem now because I'm leaving part of an asset to my loved one with special needs. So we have to address that. So I know we've stressed it a lot, but that's how important it is. We have to make sure it's current. Any changes, let's review for your accuracy. Let's make sure that it's done properly. If there are any distributions in a will or a trust, they're done in the right way. We have all the pieces connecting together to make sure we get the planning done right. And our last point here, our most important, the biggest mistake we see is not planning at all, not having a plan for the future. We work with people every day doing this type of planning. We know it's a very emotional process often. These are all topics that none of us really love to talk about. I don't like talking about my mortality. I don't like talking about the what ifs that could happen in life. But we know that they do happen. And regardless of how much wealth we have, how much planning we've done, if we don't put it all together and make sure that we have a rock solid plan, it's likely that things aren't going to turn out the way we envisioned. Like I mentioned, I know we're going to throw a lot of information at you today. It's important and really demonstrates why I'm so passionate about what I do and why I want to help families. I want to make sure you all are protected, that all the hard work that you've put in over a lifetime, not only for you, perhaps your spouse or significant other, your children, your loved one with special needs, that everybody's place in the family is taken care of financially. We want to think about quality of life for everyone. We want to think about everyone in the family, your wishes being honored, and we want to make sure everyone's protected. So you see, again, a good summary of all the things we need to look at and some of the tools that we'll use in this type of planning. Our loved one is really at the heart of what we do. We want to make sure that we address all these things properly with our special needs loved one. But we've talked about the entire family throughout the presentation because that's how important it is. Everyone's impacted. And the other reason I love what I do is it's really a labor of love. The people that I get the privilege of working with do this because they love their family. They love their child with special needs. They want them to have a wonderful, dignified quality of life and make sure that they're taken care of. And that's what we put into practice with our planning. We get the tools in place, we get the plan in place to make sure that your wishes are honored and that they live a quality life and get to be around people that love them and get enjoyment like all of us deserve in life. So see the various points here. We've talked about titling of accounts and beneficiaries, special needs trusts, thinking about caregivers as they get older, making sure that we find a level of care for them that's appropriate. whether it's a form of independent living, all the way up to perhaps assisted care. Well, depends on what their needs are. We want to make sure those are honored. For your entire family, make sure that there's estate planning done. We want to make sure your family has medical directives. Everyone in the family, power of attorney, make sure that those things are talked about. Mentions here letter of intent. That's our last point I'll talk about. Letter of intent is the story of your loved one. I talk about a lot about my cousins. I have twin cousins that were born with a lot of physical and intellectual disabilities. They're also on the autism spectrum. They have a lot of unique things that are required for their care. So my aunt and uncle have done an amazing job of documenting these things and talking about exactly what helps them thrive, what care gives them the most benefit through the day. I love talking about the fact that when they were little, they're 40 years old now, my aunt and uncle, particularly my uncle, would take them on car rides if maybe they were having a bad day, and he would just get them out of the house and they would enjoy a car ride. Well, they drove past the airport. The boys got quiet. They were just in awe of the airplanes. They sat there for hours watching them take off, land, and that's a practice that my uncle does down to this day now. My cousins love airplanes. It brings them joy. If they, even at home, before the days of Amazon and the internet, my aunt would come over to visit. We would go scouring the area for airplane toys or order a mail order. So that would be something if you walked in the door and my aunt and uncle weren't around and you're trying to connect with these two men. Well, how can I connect with them? How could I help them and maybe make friends right away? If you knew about their love of airplanes, that would help you out a lot. And then getting into all the things that really benefit your loved one. What's their medical situation, their likes, their dislikes, food, all of that can go into a letter of intent. Nowadays, it doesn't even have to be a letter. It could be an audio recording. I've seen video recordings. It's the story of your loved one, someone that would be earmarked for their care, everything that they want to know about your wishes, your dreams for them, and what care they need on a day-to-day basis. So how to get started with the planning process? Well, it always starts with a conversation. We talked about the legal aspects. We talked about getting the right team in place, making sure that you work with a good attorney, and make sure that you work with a financial professional that focuses on special needs. I mentioned the ChSN designation, and I'm also a special care planner, as mentioned. So this is something I do every day and take great pride in doing it, making sure that we set up a rock solid care plan for you, for your loved one. And we want to make sure that we always focus on not only the financial aspects for the entire family, critical part of what we do, but also a life care plan. Everything that goes into helping your loved one get the care they deserve, the quality of life that they deserve, and brings peace of mind to the family. That's what we want to provide, peace of mind for the family, making sure that you have all these important issues addressed. We talked about all the negative things that can happen, but when we do the planning, our goal is always to take failure off the table. We want to make sure that that's not an option, that regardless of what could happen in life, we have the tools in place, we have the plan in place to make sure that your plan for your family and for especially your loved one with special needs, that it is going to thrive and that we make sure that it's successful. So like I mentioned, a lot of information we've talked about, very important. And I always stress to everyone we work with, we take these things one day at a time. I know that's how you have to live life. It could be overwhelming to think about all these things at once. Well, we are going to address it one thing at a time. We're going to take care of the most important things first. We're good at identifying the very critical things that we have to take care of, but then we're also going to make sure that we look at all of this as a strategy that's going to take time to implement, And we're looking at a lifetime of care. So this is going to be an ongoing dynamic relationship. Those are our favorite ones. And those are exactly the type of quality relationships we like to build with our clients, people we work with. So just last point here, if you want to figure out how to get a hold of us, contact me to talk about anything we've covered today. We're going to send you the recording. I do a lot of educational events here locally in Michigan. Please feel free to join us. You can contact me at staltfinancial.com/special needs. We have a link right on there on our webpage that you can get a hold of me via Calendly. Set up just a quick phone call, 15 minutes, introductory phone call. We have a conversation. We can see how we can help and make sure that we can provide you some information on how to get started. You can always call me or email me as well. Information's right on our website as well, and make sure that you have a variety of ways to get a hold of me. So really want to thank everyone for your attendance today. I really appreciate you taking the time to join us and consider these things. And like I mentioned, if you need any assistance with this planning, make sure that you and your family are taken care of. We'd be honored to talk to you and see how we can be of assistance. So have a wonderful day. Thank you so much. And again, I appreciate your time.